Lawyers, what was your most satisfying gotcha moment in court? Story 1. My client's house burned down after an explosion in the fuel oil tank used to heat the property. It was clearly the oil maintenance company's fault. But to make things worse, his homeowner's insurance, from a very reputable company mind you, refused to pay out. Their excuse? A ridiculous technicality in the policy. The policy did cover damage caused by the oil heater, but the insurer claimed it was the storage tank that exploded, not the heater itself, and therefore not covered. They denied the claim, worth about $1.2 million, and that's when I stepped in. During a deposition with the claims adjuster, I asked how she came to the conclusion that the storage tank wasn't considered part of the heater system. She confidently replied that she'd relied on her expert witness, an engineer. What she didn't know was that I had already looked into this so-called expert. The guy had zero engineering education or credentials, not even close. Now, in most cases, you don't get attorney's fees. But if an insurance company denies a legitimate claim in bad faith, you absolutely do. Her little admission that they denied a $1.2 million claim based on the opinion of a fake expert ended up costing the company an additional $500,000 in legal fees. All told, their technicality turned into a $1.7 million payout. Story 2. A former client of mine filed for bankruptcy and brought an action against his landlord, claiming the landlord violated the automatic stay. To prove damages, he said he'd paid my firm legal fees related to the landlord's actions and wanted to use that to show the court he'd suffered financially. Instead of asking me directly, his bankruptcy attorney subpoenaed me to testify at the hearing. He gave me a general heads up, basically, just verify that you billed him for legal services related to the landlord dispute. Fine. The attorney first calls his client, my former client, to the stand. The client testifies that he hired my firm to deal with the landlord and paid for those services. Then I'm called up to confirm the invoice. I immediately object, noting that answering may violate attorney-client privilege, and I wanted to cover myself in case the bar ever came asking. The judge overrules the objection and orders me to respond. I look at the document and say flatly, "No, this is not my invoice." The bankruptcy attorney blinks. "But this is your firm's logo and letterhead, right?" "Yes." "And you provided these legal services?" "No." Cue awkward silence. A few more questions and it all unravels. The client forged an invoice from my firm to pad his bankruptcy case with fake damages. The kicker? I had represented him once, but in a completely unrelated matter. He tried to use my name and fabricated paperwork to score a payout. And no, I didn't warn his new lawyer ahead of time. If you commit perjury and drag my name into it, you're on your own. 2 takeaways. Clients, tell your attorney everything. Attorneys, create a space where they feel safe enough to do so. Story 3. I was cross-examining a custom home builder who had a lump sum contract with my client, meaning a fixed total price, not a cost-plus agreement. The builder was suing for extra costs, claiming he put in 20% more labor and materials than budgeted and deserved to be paid for it. We were walking through an old email between him and my client, where they'd negotiated the total price. And then, completely unprompted, he drops the bomb. I knew I couldn't build it for that price. I snapped my head up. My supervising partner snapped his head up. Opposing counsel turned white. It went like this. Me: "You quoted my client X for the house?" Builder: "Yes." Me: "And you knew you couldn't build it for that amount?" Builder: "Yes." Me: "And you knew the homeowner was relying on that number?" Builder: "Yes." Me: "And they wouldn't have signed the contract if you'd told them the truth?" Builder: "Yes." Me: "And you told their lender you could build it for that amount?" Builder: "Yes." Me: "And the bank relied on that to approve the loan?" Builder: "Yes." That's textbook fraudulent inducement. 5 minutes of testimony, entirely from his own mouth, and his case was toast. We didn't just win. The arbitrator threw the whole case out and slapped the builder with punitive damages, all because he casually admitted under oath that his contract was a lie. That's wild, and such a perfect example of a prosecution collapsing under its own lazy assumptions. Your lawyer's response was legendary. That's not his apartment. Clean, surgical, devastating. And the fact that their star witness couldn't even get your address or neighborhood right, that's not a minor oversight. That's the kind of blunder that shows the whole case was built on sand. Stakeouts, photos, testimony, all pointed at the wrong person, the wrong place, the wrong story. It's insane how close some people come to losing everything over completely false accusations. And in your case, it sounds like the system only barely caught the error in time. Thank you for your service and for having the nerve to sit through that circus and walk out with the truth intact. If you ever write a book, That's Not His Apartment is a solid title. Story 5. That is absolutely scorched earth justice, and well earned. The fact that the rookie literally said, but he's not intoxicated, and it's caught on Bodycam, that's gold. That's not just misconduct, that's premeditated abuse of power, with the cam turning off for the exact 7 minutes they needed to manufacture a case. You didn't just defend your client, you exposed a system failure. And that judge writing a letter blacklisting the FTO, that's rare and powerful. An official, written, "You're done here." It sends a message. Some lies don't get brushed under the rug. Your client was lucky to have you, and hopefully his civil case lands the financial equivalent of that "oh shit" face in the courtroom. A real justice mic drop. Story 6. That's the legal equivalent of the landlord handing you a signed confession gift-wrapped with a bow. Getting inside the landlord's head is always the hardest part in those cases. Proving motive, not just negligence. But that voicemail? That's the smoking gun. The signed, "Yes, Your Honor, I'm doing this on purpose." You didn't just win the case. You probably didn't even have to open your mouth in court. Just hit play. We'll make the repairs as soon as the tenant is forced out. Thanks for the punitive damages, sir. Story 7. I once worked as a paralegal and investigator on a lawsuit that involved, believe it or not, dental wheels. Small circular tools used to grind teeth. Doesn't sound thrilling? Just wait. Company A, a small family-owned business hidden in the middle of nowhere, had been making the best dental wheels in the industry. The employees were lifers. Every single one of them had worked there for over 30 years. When the original owner passed away, the company was sold to a giant international firm, Company B, who shut down the old plant and tried to recreate the formula in their own labs. Spoiler, it didn't work. Now enters Company C, another international company that lost the bid to buy Company A. When they heard Company B was struggling, they bought the now-abandoned factory and rehired the original staff. Production resumed, and the product quality back on top. Company B, seeing this, sued Company C. Their claim? Company C had stolen trade secrets by hiring the employees who used to make the product. They even got a federal judge to temporarily shut down Company C's production line. That's when I came in. My job was to interview the old employees. Most of them said they learned the process from someone else. But one delightful older lady, who insisted I take a plate of cookies and tried to set me up with her granddaughter, let something slip. I asked her, "So who trained you?" She said, "Oh, I just followed the directions on the wall." I paused. "What directions?" "You know," she shrugged, "the board with all the steps. It's always been there." I nearly dropped my pen. We went to the old factory, found the janitor, and sure enough, there it was. Covered in dust, bolted to the wall, was a board with the entire manufacturing process printed in detail. No one had thought to remove it. And by leaving it behind, Company B had legally abandoned the trade secret. When they sold the building, they unintentionally sold the formula with it. Here comes the second unexpected part. Even with the board, Company C still couldn't quite match the quality. Why? Because those sweet old ladies had quietly refined the process over decades, tweaking and improving it so subtly that even the instructions on the wall were outdated. The federal judge chuckled when we brought the dusty board into court. When the janitor testified, smiling in every photo, holding the evidence like a trophy, even the judge couldn't hold it together. The result? The factory reopened. Company B and C settled, agreeing to share the formula but never sell it. And the ladies? They went back to making the best dental wheels in the world. No labs, no engineers, just decades of wisdom and a chalkboard that no one had ever bothered to erase. Story 8. My brother, an attorney, once handled a case involving a man who claimed he was permanently disabled from a workplace injury. According to the man, he couldn't lift, bend, or do any strenuous activity. The case was shaping up to be expensive. If the court sided with the claimant, my brother's client was going to be out thousands. During a deposition, the man casually mentioned that he was having his house remodeled, sounding a bit too excited about how he was going to spend the money. Something didn't sit right with my brother. Later that week, he decided to take a detour and drove past the man's house, just out of curiosity. And there, in plain view, was the man carrying bundles of roofing shingles up a ladder onto his roof. This was before smartphones, so my brother didn't have a camera handy. Instead of letting the moment pass, he pulled a U-turn, drove straight to a nearby Best Buy, bought a video camera on the spot, and raced back. The man was still working, and my brother got clear footage of him climbing, hauling, bending, and working like someone in perfect health. He made multiple copies of the footage and sent one directly to the opposing attorney. The man dropped the lawsuit immediately and returned to his old job the very next week. No injuries, no disability, no settlement. Here's where the second unexpected moment comes in. Despite saving the client thousands of dollars, my brother's firm balked at reimbursing him for the video camera. He eventually got paid back, but to this day, every time the story comes up, he grins and adds, "Still waiting for them to reimburse the batteries." Story 9. A client came to me after their $60,000 car blew up just days after an oil change. The engine was toast, completely destroyed. They had taken it to a local shop, and everything pointed to the wrong oil being used. But there was one problem. We couldn't prove it. The oil had leaked out, the engine was gone, and any clear evidence was long gone with it. At first, the shop denied everything. "We always use the manufacturer-recommended oil," they claimed. No way to contradict them. No receipts, no samples, nothing. But something didn't sit right with me. I subpoenaed their bank records, and that's where I noticed something odd. All their oil purchases came from Costco. So I called up Costco and got historical pricing for the different types of motor oil over the last 2 years. Then I did some math. Comparing the amount of money they spent monthly on oil to the market price for the correct oil, it was clear they were buying something cheaper, much cheaper. The only way their numbers added up was if they were using low-grade oil, the kind absolutely not meant for a high-performance vehicle like my clients. The moment we sent over our analysis to the shop's attorney, complete with a tidy spreadsheet and Costco price history, they folded. Surprise 1, the entire case was won with a calculator and Costco price sheets. Surprise 2, the shop not only paid the full settlement, they sent a check for a rental car too. My client laughed and said, "I wish my engine had blown up sooner." Sometimes the receipts aren't under the hood, they're in the bank statements. Story 10. Ex-wife gave away custody of my daughter while angrily arguing with the judge. Not a lawyer. Was taking my ex to court over custody of my kid. I had compiled a 150-page dossier, complete with a report from Child Protective Services since there was abuse in the household, text messages and tons of records of contempt of our previous agreement. My daughter has a court-assigned lawyer that is normal in these cases, which, after reading through all the materials and talking to all the parties, sided with my lawyer and I. The ex decided to represent themselves because, hubris, I suppose. Before the case was heard, in the hallway outside of the courtroom, she gave me an agreement she typed up which would grant me custody as well as some generous provisions for herself. I politely declined, as we were confident we would be getting a lot more in trail. Case was called. Testimonies in. She put on the most hilariously insane and embarrassing show for the court. In her closing testimony, she attempted to hand the judge the agreement she tried to give us. Judge refused to take it. "You can't just hand me things. That's not how you submit things into evidence. I'm not reading that." She's arguing with the judge, yelling at him and losing her shit. In the insane nonsense she was spewing, she said, "And this agreement gives him custody, which is one of the things he's after," in what I assume was an attempt to show that she's attempting a compromise. My lawyer peppers in a quick statement. "Okay, so you agree for the father to have full custody?" She snaps in heated anger. "Yes, that's what I agreed to." Our side falls completely silent, and the judge, after much effort, ends her little outburst. Gave his final verdict, which started with granting me custody and putting her in court-mandated therapy. She literally gave away custody of her daughter in a heated argument with the judge. Story 11. My client was a hard-working woman at a meatpacking plant. One day, her loose-fitting glove, the cheap kind her employer insisted on, got caught in a processing machine. In an instant, she lost her arm. We filed suit on multiple fronts. Against the plant for knowingly using unsafe gloves. Against the machine manufacturer because the safety handguard was missing. And against the distributor who sold the machine. Honestly, we included them mostly because they were in the chain of sale. We didn't expect much from that angle. The manufacturer came back aggressive. "We always include the guard," they insisted. Their story? The plant must have intentionally removed it using a grinder. It became a game of he said, she said, until the distributor's deposition. He walks in, casually hands over sale documents that were supposed to be provided weeks earlier. Everyone's annoyed until I look closely. Down at the bottom, in tiny font, is a note, "Sold without handguard." Everyone froze. It was against the law to sell the machine that way. The distributor hadn't even realized the clause was there until I read it aloud in the room. I looked over at opposing counsel. No one said a word for a few seconds. First surprise? The weakest link in our case, the distributor, turned out to be holding the smoking gun. Second surprise? We settled that same afternoon. No more fighting, no more delays. My client had her medical bills paid, got a top-tier prosthetic, and was awarded damages for pain and suffering. She told me afterward, "It's the first time since the accident I felt like someone actually saw what I went through." Sometimes, justice is hiding in 6-point font. Story 12. I was deposing a key witness in a major breach of contract and fraud case. This guy wasn't just some side character. His testimony could seriously influence the outcome. So naturally, I started with the basics. "Have you ever been convicted of a crime?" "No," he said, calm as ever. Later in the deposition, I circled back. Same question, no objections. "No," he repeated. This time, I smiled and reached into my file. I pulled out a certified indictment for felony fraud and a conviction for misdemeanor conspiracy, both with his name on them. He squinted at the paperwork and had the audacity to say, "That's not me." I didn't flinch. I calmly said, "Let's talk about your co-conspirator, your son." First surprise? His eyes shifted, his shoulders dropped. "Oh yeah," he mumbled, "I remember something about that." Second surprise? Opposing counsel looked like they'd swallowed a lemon. They had no idea their witness had a record, and now, everything their case leaned on had just cracked. That moment didn't win us the case on the spot, but it shattered his credibility and changed the tone of the entire trial. Sometimes, the biggest move is just asking the same question twice and letting the silence fill in the rest. Story 15. I once served on a jury in a medical malpractice case involving a gallbladder surgery that didn't go as planned. The patient's common bile duct had been accidentally cut, something listed as a known complication in every consent form. Still, she sued the surgeon, insisting it was due to negligence, not chance. Her lawyers brought out their big gun, a nationally known surgeon who had performed the operation thousands of times. Polished suit, authoritative tone, and an air of someone very used to being the smartest person in the room. He told us with confidence, "This kind of mistake is completely unacceptable. No competent surgeon would do it." He said it like gospel until the defense stood up. The defense attorney didn't argue with him directly. Instead, he walked us through the witness's long history of expert testimony. Turns out, this surgeon made most of his living not in operating rooms, but in courtrooms, testifying against his peers. But then, as the witness was about to step down, the attorney asked one last question, calmly, almost offhand. "Doctor, have you ever cut the common bile duct during surgery?" The room froze. He hesitated for a moment. Then, "Yes, I have." The effect was instant. You could feel the jury trying not to make eye contact with each other. We didn't need to deliberate for long. When even the expert calling the mistake unforgivable had made it himself, well, that pretty much said everything. We ruled in favor of the surgeon. Story 16. This was the only full trial I ever handled, a chaotic case between a contractor and my client. And while I'll admit my client wasn't exactly a saint, this time they were clearly the one getting taken for a ride. The contractor was suing, claiming he was still owed money. So, during cross-examination, I walked him step by step through the contract he had drafted. Every subcontractor? Confirmed. Every payment amount? Confirmed. The final total? Confirmed. Everything added up. Until it didn't. I leaned in and asked, "Where's your profit in this contract?" He froze, shuffled through the pages, scanned the numbers. Nothing. In the contract he had written, approved, and signed, he'd left out any line for his own profit. He had literally sued for a deal that, on paper, paid him zero. The judge flipped through the documents, looked back up, and without even hearing my side, dismissed the case. The contractor came in thinking he'd walk out with a big check. He left with absolutely nothing, except the sinking realization that he'd built his entire case on air. Story 17. I represent tenants in eviction cases, so naturally I've seen plenty of dramatic landlord moments. But last week's trial might be my new favorite. A classic case of one word against another. Everything came down to credibility. The landlord took the stand and, unprompted, insisted on swearing on the Bible when taking her oath. It wasn't required. She just wanted the jury to know she meant business. But then the actual testimony began. She dodged nearly every question I asked, even some from her own lawyer. It was like watching someone try to dance through raindrops, except the jury was watching and the courtroom was dead silent. Then came the moment that changed everything. During a recess, she was spotted, in plain view of the jury, whispering with her attorney and a family member just outside the courtroom. When she returned to the stand, I asked her directly what that conversation was about, and whether they were coaching her on how to answer. Her lawyer objected. The judge overruled. She paused, then answered, "My life is my life." That was all. During closing arguments, her lawyer actually leaned into the oath moment. He argued that she must have been telling the truth. After all, she swore on the Bible without being asked. That made her more credible, he said. So I stood up and agreed, in a way. I told the jury, yes, she did take the oath seriously. So seriously, in fact, that she chose not to lie. Instead, she said nothing. The jury returned after just 30 minutes, with a unanimous verdict in my client's favor. In my state, we don't even need 12 votes for a decision. But that day, all 12 came back crystal clear. Story 13. A few years back, I was representing a client in a Social Security disability hearing. His case had already been to federal court and was sent back because the judge messed up the first time. That's how bad it was. The judge had previously awarded him only $700 a month, far less than what he deserved, which was $2,100. And now we were back, with everything on the line. As soon as the hearing started, the judge pulled a scare tactic. He looked my client dead in the eyes and said, "Are you aware that by continuing this hearing, I might take away all your benefits? That you could owe everything back to the government?" First surprise, the judge legally couldn't do that. The rules only allow changes within 2 years of the original decision, and this case was already 6 years old. I turned to my client and said clearly, "He can't do that." Then looked right at the judge and added, "Your Honor, I've advised my client that you cannot take his benefits away." You could feel the air shift in the room. I waived all the usual procedures and went straight to the expert witness. I asked 2 questions. Would his previous job require lifting over 20 pounds? Has that job existed in the same form since 1999? Second surprise, the vocational expert didn't just say no, she volunteered extra information explaining exactly why my client couldn't do the job anymore and why the job no longer existed. The whole hearing took 6 minutes. That's it. The judge had no room to deny the claim. My client was awarded $158,000 in back pay and finally started receiving the full $2,100 a month he was owed. And then he cried. Not because of the money, but because he could finally afford to fly to Hawaii and scatter his wife's ashes on the beach where they were married, a promise he thought he could never keep. That was the best day of my career. Story 14. Back when I was a prosecutor, I had a guy on trial for stealing a car and evading the police. He wasn't just fast, he actually managed to escape a full-on chase and was only caught much later. His defense? Wasn't me. He insisted he wasn't the driver, wasn't even there. But here's the thing, he decided to represent himself. Now, what he didn't realize is that all jail calls are recorded. And this guy, he talked a lot to his girlfriend about everything. About the car, the chase, and even how he thought he almost got away with it. So when I handed him a folder and said, "These are your jail call transcripts," the expression on his face was pure panic. First surprise, he had confessed to the entire crime, just not in court. But wait, it gets better. Second story. Another defendant, also representing himself, was on trial for burglary. An elderly neighbor had witnessed someone fleeing the scene. During trial, the defendant stood up, proudly handling his own cross-examination. He asked the witness, "Now, when you saw this person running from the house," and before he could finish, the witness pointed straight at him and said, "You. I saw you running from the house." The courtroom went silent. And that, my friends, is why lawyers go to school for this. Ex-wife X was suing my client, the new girlfriend, NG, for running her over. Sounds dramatic, right? And it was. According to EX, she was just standing there, yelling a bit, when NG suddenly drove off and hit her. She claimed she'd never touched the car, never punched it, never kicked it, never dove onto the hood, just a bit of shouting. And then, boom, injuries, surgeries, and a lawsuit. But here's what really happened. NG had been sitting in her car trying to get away, while EX was pounding on it. She blocked the car, tried the handles, even jumped on the hood. After a short pause, NG slowly started driving, trying to flee, not fight. That's when X slid off the hood and got hurt. In the deposition, X sticks to her story. She was just yelling, calm, nonviolent, passive. So I ask, what was NG doing while you were yelling? X answers, she was just sitting there, hands on the steering wheel, staring straight ahead, locked in the car. Then I ask, "How did you know the doors were locked?" Silence. She blinked, shifted, and realized she just admitted to trying to get in. That lawsuit didn't last much longer after that. Story 19. This was one of those cases where you realize just how far certain institutions will go to avoid accountability and how hard you have to fight to make them play by the rules. My client? A fry cook, charged with a misdemeanor DWI. Not a headline case. But like every defendant in this country, he had a constitutional right to see any evidence that might help his defense. It's called Brady material, and it's not optional, it's mandatory. Here's the problem. The university police agency involved refused to provide that evidence to the district attorney. The DA, rather than pushing back, shrugged and said, "You defense lawyers can just subpoena the chief of police yourselves." Most lawyers didn't love that idea. I really didn't. So I skipped the chief and subpoenaed the president of the university. That move set off a storm. The Texas Attorney General's office, yes, the state AG, got involved. They filed a motion to quash, calling the subpoena a nuisance, arguing that the university president shouldn't be bothered with routine clerical matters. Spoiler, the judge didn't like that framing. Calling constitutional due process clerical was a swing and a miss. On trial announcement day, an attorney from the AG's office showed up, polished suit, perfect haircut, and asked smugly, "You really think you're going to get what you came for?" I smiled. "We'll see." In court, I told the judge we couldn't proceed. The DA hadn't turned over the required evidence. I asked to call my witness, the university president. The judge nodded to the bailiff. Panic. The AG jumped up and said the president wasn't there, but he'd brought the police chief instead. A woman in her 40s walked in wearing a crisp uniform. He tried to let her talk freely, but I objected. Criminal proceeding, she needed to be sworn in. Sustained. Then I objected again. Criminal proceeding, testimony had to be in Q&A format. Sustained. The AG froze. No prep, no plan. He even said out loud, "I've never been in a criminal proceeding before," looking at the judge like a kid hoping for help on a test. He finally asked, "Have you provided all Brady material to the DA?" The chief said yes. Then it was my turn. I asked, "Can you tell the court what Brady material is?" She answered, "Sustained written complaints against the officers involved." The judge jumped in. "No, it's me. Judge, please don't give her the answers." He apologized. We continued. Her answers showed she had no real understanding of what Brady material even was. Then she swore, under oath, that she had already given all such material to the DA a month ago. That was a mistake. The first assistant DA stood up and asked for a break. Everyone, the chief, the DA, the AG, disappeared into the DA's office. When they came back, the AG asked if I'd withdraw my subpoena because they had worked something out with the DA. I told him, "You're talking to the wrong party. Your deal with the DA means nothing to me. Let's get your witness back." He snapped, "That's bullshit." I replied, "We're swearing now? Cool, go fuck yourself." Back in court, the chief was sworn in again. This time, she testified that just yesterday, she had learned about internal affairs files that might contain Brady material, something she somehow didn't know the day before when she swore she'd turned everything over. That's perjury. Aggravated, because it was meant to deny my client, a fry cook, his rights. The trial was postponed. The judge ordered the DA to submit the files for in-camera review. I insisted that I be allowed to go through them too. After all, only I knew the full context of the case. The judge agreed. If I flagged something as Brady, then it was Brady. The president of the university still hasn't testified, but the court kept the subpoena alive. And next time, she's expected to explain why a state-funded institution thinks it doesn't have to follow the Constitution. And me? I'm not done yet. I'm going to keep pressing until this police agency either starts respecting the law or falls apart trying to avoid it. All of this, just to protect one fry cook. Story 20. Here's how it unfolded. One of those cases that started as a total loss and turned into a career-defining win. My brother is a divorce attorney. Nothing too flashy, mostly grueling custody battles and paperwork. But this one case stood out. His client? A father in the middle of a brutal divorce, accused of horrifying abuse by his own children. The accusations were disturbingly specific, repeated across multiple depositions. The mother brought in social workers, therapists, everyone was convinced. Things looked hopeless. But something didn't sit right. Then came the turning point. My brother was combing through the official deposition transcripts, the ones conducted by trained professionals, all sworn and recorded, when he spotted an odd sentence at the end of one kid's testimony. "Did I hit my marks?" That phrase hit him like a thunderclap. See, before law school, my brother had spent a couple years trying to make it as an actor in LA. He failed miserably, but he never forgot the lingo. Hit your marks is classic actor speak. It refers to standing in the exact place a director tells you to so the camera can catch the shot. No ordinary kid would say it, certainly not in a high-pressure legal setting. It was like hearing a fourth grader ask, "Was my blocking tight enough for the two-shot?" So he dug deeper. He subpoenaed the wife's personal bank records during discovery, and there it was, payments to a private acting coach. From there, things unraveled quickly. He tracked down the coach, called them in for a deposition. The moment they sat down, panic set in. Instead of lawyering up or stalling, the coach practically begged for leniency and handed over the smoking gun, DVDs. Hours and hours of rehearsals with the children, practice interrogations, coaching sessions where the kids were taught what to say, how to cry, when to pause, what phrases would sound believable. Everything, scripted abuse. The courtroom flipped. My brother said it was the only time in over 20 years of practicing family law where he had a true courtroom reversal. The case collapsed. The falsehoods were undeniable. The mother's credibility was gone. The judge transferred sole custody to the father on the spot. From being branded a monster to walking out with his children, all because of one stray line and a lawyer who knew how to listen. It wasn't just justice. It was earned redemption. Story 21. Here's the kind of petty masterpiece only a 1970s divorce could produce. Not a lawyer myself, but this is family lore. My grandparents had what was, for a time, the longest-running divorce settlement in Los Angeles. It dragged on for nearly 5 years, a legal war of attrition. My grandpa, stubborn to the core, was ordered to pay my grandma several $1,000s a month in alimony, plus her health insurance, car insurance, and even a new vehicle, all until she either got remarried or got a job. She chose neither, on purpose. But the real blow-up came courtesy of a Hawaiian vacation. One year, while my grandpa was living his best life, he mailed her a postcard from Maui. But it wasn't just a scenic wish-you-were-here note. It was a full-on taunt, something cheeky along the lines of, "Soaking up the sun with your alimony money. Hope you're enjoying funding this tan." Grandma didn't laugh. She drove the postcard straight to her lawyer. That single piece of mail, self-authored and postmarked from paradise, completely tanked his case. It showed clear bad faith and a total disregard for court orders. From that moment on, the court had no sympathy left for him. He never won another motion. And to this day, decades later, he's still sending her checks. The car he was forced to buy her, it's been sitting untouched in her garage for years. She can't drive anymore, but keeps it insured, just to spite him. The car's dead, the marriage is long dead, but the revenge, still alive and well, and fully billable. Story 22. That sounds like a dramatic retelling of a real case, but it's actually the exact plot of 12 Angry Men, the classic film and stage play. In it, a young man is accused of murdering his father, and the case seems airtight. But one juror, juror number 8, famously played by Henry Fonda, slowly dismantles the prosecution's evidence, pointing out every inconsistency, bias, and assumption. His calm reasoning and refusal to rush to judgment gradually sways the rest of the jury to reconsider their verdict, ultimately leading to a unanimous not guilty. If your story is inspired by real events, it's a striking coincidence. But if it's just a paraphrased version of the film, it's still a powerful example of why reasonable doubt matters so much in criminal trials. Story 23. That's a clever jurisdictional play, a textbook example of using international procedural dynamics to your advantage. By getting the opposing party to accept service in the U.S., you effectively created an implicit admission that the U.S. court has jurisdiction. So when it came time for the Chinese court to decide whether it should proceed, the optics were clear. The defendants had already acknowledged a U.S. venue as valid by engaging with it. That single procedural act, signing for service, undercut their entire jurisdictional argument in China. Elegant, subtle, brutally effective. Story 24. The case of the vanishing paint, how a missing detail won a luxury car lawsuit. This wasn't my case, it was one of my mentors, but the lessons stuck with me ever since. He specialized in personal injury and high-value accident litigation. One particular case involved 2 incredibly expensive vehicles. His client was driving a brand new high-end car. The other party owned a rare vintage collectible, the kind collectors insure for absurd amounts and treat like sacred objects. There was no dispute about who caused the accident. The issue was money, specifically the damage. The opposing side claimed the front of their vintage car had suffered extensive paint damage in the collision. But not just any paint. They argued the car had a now discontinued custom-blended paint that had to be remixed from scratch and applied by a specialist. The cost? Astronomical. Their expert went into theatrical detail, describing the uniqueness of the finish, the rare minerals in the mix, and how even a dime-sized blemish could ruin the car's value. It sounded compelling. Until cross-examination. That's when my mentor leaned in. He gestured calmly to the photos already in evidence, clear shots of the 2 cars post-collision. The contrast between them was stark. His client's car was dark metallic blue. The vintage car was a glossy candy apple red. Then he asked, if the impact was severe enough to damage the paint, where are the red paint chips? Silence. They're not embedded in the bumper, not scattered on the pavement, and not anywhere in the tow yard photographs either. The opposing expert blinked. No answer. He repeated the question, slowly. If the paint was cracked or stripped, wouldn't there be some sign of it? Still nothing. The courtroom shifted. Jurors sat up. It was subtle, but the defense's credibility was already starting to bleed out. The absence of something that should have been there said more than 1,000 technical explanations ever could. By the time the case wrapped, that one observation had quietly unraveled a mountain of carefully constructed argument. Without physical proof of the damage they claimed, the other side's case collapsed in on itself. Verdict? The court ruled overwhelmingly in favor of my mentor's client. No dramatic speeches, no last-minute confessions, just one careful, grounded question that no one on the other side could answer.